Good afternoon and welcome to Gilligan Shepherd TV. Very fortunate today to have Paul Chambers joining us. He's a director with Anderson Cray Lai, a niche law firm who we work with on a really regular basis. Good to see you again, Paul.
Yes, and you too, Michael.
Cool.
Good afternoon.
Yeah, on what's starting to feel like winter. What we've got today is, we've asked Paul to join us so we can just have a conversation and address some of the legal challenges that both landlords and tenants are facing. And just to get Paul's insight, this is Paul's wheelhouse. This is something he deals with day in, day out, and of course over the last month or two has been heavily involved with loads of different organisations and people who are facing the challenges with how to navigate these times and what this is throwing up. So to that end, I'm just going to run through a few questions and see how we go. Is that all good?
Yes, very good.
Cool. So when the lockdown 4 really kicked in, and a lot of the commercial leases, there was the provision in there that if you're excluded or couldn't use your premises, you could agree to a reduction or pay what is fair. Can you describe how do you define fair, both from a landlord's perspective and from a tenant's perspective? Because I'm guessing this is quite a subjective measure.
Well, I mean, it's ostensibly an objective measure, but it's not well defined, or it's not defined at all, rather.
Mm-hmm.
So this clause 27.5, which is in the Auckland District Law Society form of deed of lease, it's been in there since 2012 in response to the Christchurch earthquakes, when there were a lot of premises in the Christchurch red zone which weren't damaged themselves, but because the government had created this red zone, they were inaccessible. So in the absence of this provision, those tenants would still be paying a full rental.
Mm-hmm.
So in response to that situation, the government or the Law Society put this clause into the lease. And so since 2012, it's been in there, but probably I would say very few people would have ever looked at it terribly closely or considered whether it needed to be negotiated or considered during negotiations to enter into the lease. But anyway, now it's certainly come to the fore.
Yep.
And it's having a widespread impact across New Zealand, given the predominance of this form of deed of lease for commercial premises in New Zealand. So the way it works is that if government actions essentially in response to an emergency situation, which in this case would be the pandemic, prevent the tenant from having full access to the premises, then the tenant is or a fair proportion of the rental and outgoing ceases to be payable. So as you say, what is a fair proportion of the rental and outgoings? Well, the clause itself gives no guidance whatsoever. It merely refers to the term. And to date, the clause hasn't been looked at by the courts. It's only been in there since 2012. There hasn't really been a situation that I'm aware of where that clause would have had any widespread application. So yeah, there's really been no opportunity for litigation to be brought before the courts for a judge to actually give a view as to the meaning of that term. So in the absence of any judicial guidance, we've got to look at the word itself and just think about what the authors or what the parties would have intended it to mean when they entered into the lease. And so for me, the primary, I mean, there's a range of perspectives on this. If you look at the commentary, I think probably law firms who do any amount of property law has probably put out an opinion on this clause. And if you look at those views, then there's quite a diversity of opinion as to how the clause works or what should be taken into account in ascertaining fairness. I suppose for me, the first thing to think about is what benefit is the tenant getting from the premises while the effects of the emergency are being felt. So in this case, So during the level 4 lockdown, what benefit was the tenant getting from the premises? Were they still able to use them? And then you can think about the kind of the range of scenarios. And so if you're a cafe, for instance, and you're completely prevented from using your premises, so you lease premises to operate a cafe and to sell coffees and sandwiches. You can't do that anymore. The premises during the period of lockdown are close to useless for you because they're only good for storing your equipment and your coffee beans. In which so that tenant would be saying, well, fairness for me means that I should, the rental in that case might be reduced to say 25% of the usual level. So that's at one extreme. You're never going to get to a full abatement of 100% because that's not quite how the clause works. So it's going to be somewhere less than 100%. So a 75% abatement, so you end up paying 25%, might be appropriate for the cafe, or at the other extreme, you might have a warehouse which is still being used by the tenant because they're still storing their goods in there, and that's why they lease the premises. So in that case, it might only be a 25% abatement.
Interesting.
And then you've got office premises where the premises themselves can't be used, but the tenant actually isn't so heavily impacted by the lack of use of the premises because they can still work remotely from home. So they will probably fall somewhere in the middle, so maybe around 50%.
Interesting. We've seen we've seen a number of landlords who have said to their tenants, I said, look, given obviously the impact, we don't know what it is. We're going to give you a 3-month rent holiday. So what you're saying is they're actually under no obligation to do that.
That would be a generous landlord who, if the landlord was interpreting clause 27.5 as giving them that obligation, then they would be taking a very generous perspective on that. I mean, a landlord might be willing to do that because they simply see the tenant as being a good tenant whose business is now in difficulty, and they want that business to remain viable. So they see in their long-term interest to give a good discount like that, if it means that the tenant can survive.
So in a situation where a tenant has said, look, my business is going to be impacted, I can't use it. I can't use the premises to an extent to be able to generate revenue. My revenue's fallen off a cliff. I'm going to pay you X. And the tenant has started paying what they consider fair for their own personal circumstances. Because I think if I understood you right, Paul, depending on your personal circumstances will impact what is or isn't fair. What happens in the situation when the landlord doesn't like it, doesn't think what you've offered or what you're paying is actually fair? How does the process work from there, given, as you've said, that it's relatively new and untested in terms of precedent?
Yeah. I mean, what I've seen a landlord assert to a tenant that that the provision requires that the parties agree on the appropriate abatement before the tenant is entitled to pay a discount amount, but that's not correct. That's not how the clause works. The clause is automatic. Automatically, upon the event occurring, a fair proportion of the rent and outgoings will cease to be payable. The question is what's fair, but that's an objective determination that can be determined. But it doesn't require that the parties agree before the abatement applies. So of course, the first position has to be the tenant, who will probably be the one who will need to instigate the discussion because it's for the tenant's benefit. Mm-hmm. They go to the landlord and they say, I need a 75% discount. The landlord says, forget about it, should be 25. Hopefully the parties can agree, and maybe they agree on 50 or whatever. If they can't agree, then the advice to the tenant would be pay what you think is fair, and if the landlord isn't happy with that, then the onus will be on the landlord to commence the arbitration proceedings to have an arbitrator determine what is fair, because the Auckland District Law Society form of deed of lease also provides that dispute resolutions by way of arbitration. So, so if the parties are in disagreement about a matter such as this, arbitration would be the way to go to resolve it.
And that arbitration process, is it timely, cheap? How does it work? Either from, obviously the landlord is instigating it. What does that actually mean?
It's like a private form of judicial process. So in the same way that the landlord could go to court and they could file their claim in court for a judge to make a decision. In this case, the parties agree on who the arbitrator is going to be, who will be a senior lawyer of some kind who has a specialty in arbitration, and then the arbitrator has the role of the judge who makes the decision. So, but the arbitrator will run it in a similar to a court process, essentially, where the parties make submissions. There may be evidence to be heard. In fact, in this case, there would be evidence because the tenant would be having to produce evidence of the impact on their business as to why the percentage they say is fair is fair. Equally, the landlord would probably be wanting to present evidence as to why the landlord says, well, you need to take into account what's fair to me as a landlord. So the landlord, and I guess an open question for fairness is, to what extent is the landlord's circumstances taken into account? Is a landlord who is heavily indebted and who requires the rental to pay the debt treated differently to a landlord who has no debt?
That's interesting. So do things like, the means for either a tenant or a landlord to receive some benefit from the government, for example, whether it be an interest-free loan to pay outgoings or whether it's some sort of business loan to get them through this period, would that ever get taken into account in that sort of arbitration?
I mean, given the lack of clarity with the clause and the absolute reliance on this term fair, you'd have to say that if an arbitrator was looking at what's fair, the arbitrator would be free to take into account any circumstances that the arbitrator considered to be relevant.
Right.
So the circumstances of the tenant, the availability of government support, the circumstances of the landlord. I guess to the extent that the clause was negotiated by the parties at the time of entry into the lease, for instance, possibly it wasn't even considered or discussed, but it's possible that it was.
Well, can I suggest that it might have been a surprise to many landlords and tenants to have seen that such a clause exists?
I would say absolutely, yes. Yeah. I mean, to be honest, I had a client who approached their landlord at the beginning of the lockdown and said, "Oh, we're struggling. Can we have a discount?" And the landlord said, "Yeah, we'll give you a discount. We'll give you," I think they got 35%. And then they came to me a couple of weeks later and said, "Oh, we did this great deal with the landlord." And I said, "Well, actually, the landlord was required to give that to you under the lease." They had no idea. They thought that the landlord was acting out of the generosity of their heart to give them some kind of discount when they didn't realise that they had a contractual entitlement to it.
Wow. So ultimately, your values as a business person, whether you're a tenant or a business, obviously play a part in how you enter this negotiation. And I guess one of the principles of when faced with the pandemic is everyone has to suffer and probably should endure some pain. Each to their own means. Shouldn't one party be suffering disproportionately to another? Is that a reasonable observation, Paul?
I think that's extremely relevant. Clauses and the landlord's circumstances do need to be taken into account. But then that does go back to that question that I considered before as to about whether do you treat a landlord different who is heavily indebted and is absolutely reliant on this rent to pay rent, to prevent them from going into breaching their obligations to their lender. From a landlord who has no debt and doesn't have those same issues to contend with.
So, Paul, if we were to sort of look forward in terms of post this pandemic recovery and some of the lessons that can be learned, if you're either a landlord or a prospective new tenant or prospective new landlord, what are some of the terms that should be considered, or how would you go about some of advising a client, or whether it be a landlord or a tenant, for example, about the standard lease? Would you take 27.5 out? Would you leave it in? How would you approach commercial leases following the experience we've had with COVID-19?
Well, I guess, just looking at this clause in particular, what parties want is certainty. It's not really doing, anyone any favours, having this uncertainty about, what fairness means. That they'd like to know, where they stand with this. Given now we're in the midst of COVID-19, the government has set up an alert level scheme where we kind of know what level 4 means and level 3 means and level 2 might mean, or at least, fairly soon we might have some more detail about that. There would be nothing stopping parties who are entering into a lease now saying, if the government puts us at level 4, then, the rent will abate by 75% and the outgoings will abate by 50%. If we're at level 3, then it's 50% and 25. If we're at level 2, then it's 0%. But there's no reason at all why the parties couldn't reach an agreement on those issues in advance.
So we will expect to see some changes in how landlords and tenants engage as a result of this.
Yeah.
So one of the questions we've also had asked, or we suspect is going to become an issue, is what happens when it comes to the settlement, or when either acquisition or disposal of a property, for example. If it was due last week or next week or in a month ago or in the next month, is this pandemic sort of grounds for a cancellation, under a sales and purchase agreement for a building or some bare land?
Well, if we're talking about it, I guess, just with a sale and purchase agreement for a house, someone's selling the house, someone's buying the house. The only impact that COVID-19 will have on that process will be the vendor's ability to deliver vacant possession to the purchaser. So the vendor's obligations at settlement are to deliver vacant possession and to transfer title. The purchaser's obligations are to pay the purchase price. The purchaser doesn't have to take possession at settlement, so it's up to them as to whether they wish to do that or not. So the only implication that COVID-19 is going to have on that process would be the vendor's ability to perform. That the purchaser will still be able to perform. So, non-performance is really a risk that the vendor has, in the same way that the vendor is at risk that their moving company that they engage to get stuff out, doesn't turn up on the day they're supposed to. It's a matter that's outside the vendor's control, but the vendor is still liable for it at the end of the day. And I suppose there's a process that the agreement provides for if someone can't perform their obligations at settlement. There's a settlement notice process which gives the defaulting party 12 working days to comply before the agreement can be cancelled. So there's kind of a built-in buffer.
Right.
If there is some hold up at settlement.
Now another question, which I know sort of dear to your heart and you've dealt with, when we look at construction contracts, developers, most contractors have issued a lot of suspension notices on, for example, as a result of this. What are the consequences of this for the property owner? You know, in terms of insurance, and there's obviously costs associated with a delay in being able to complete construction, for example. Where do those costs fall as a result of the pandemic?
Well, I mean, the answer to that very much depends on the contract that the parties are under, and there's any number of forms of contract, and often those contracts can be quite bespoke for the situation, particularly if it's a commercial construction. Residential construction are much less likely to be customised. They're more likely to be a standard form contract. So I suppose that, but just thinking about I guess the two most common standard forms of contract, you've got NZS 3910 2013, the most common form of contract for commercial constructions, or 3916, which is very similar to 3910. And then you've got the Master Builder's residential construction contract, which is commonly used for residential construction. So I guess in terms of insurance, one party will be required to have construction insurance during the course of the construction. So it's possibly, if it's a whole new build, it's probably the contractor who has that insurance policy, and they will, under the contract, they'll be required to maintain that insurance until practical completion. So that would cover the period of any suspension, because that's a period that's going to occur prior to practical completion. At the commencement of the suspension, the contractor would probably have the obligation to secure the site and make sure that that nothing's going to be damaged during the period of suspension. So they'll be locking it up and just making sure things are covered.
Would that also include, private security, for example, additional fencing, or along that sort of obligation and cost would be borne by them?
Potentially, yeah. I mean, certainly fencing, additional fencing could be required. Yeah, I guess the nature of the construction would indicate whether security was required or not. And in terms of, so under the master build contract, the same thing will apply. You'll have to have that insurance. Well, the party who's required to have the insurance will have to ensure that the insurance is maintained over the course of the suspension. In terms of who bears the costs relating to the delay, under both contracts, a suspension would be treated as a variation. So if works are suspended, then the contractor would be entitled to a variation. So they'd be entitled to some kind of compensation for their costs relating to the delay. Under the master build contract, those provisions are more favourable for the contractor. Essentially, any time that the contractor is entitled to an extension of time, which includes circumstances where the extension is required due to circumstances outside of the reasonable control of the contractor will be entitled to an extension of time, and they'll be able to claim for a variation. 3910 is more restrictive and less favourable to the contractor, so that an extension of time which doesn't involve a suspension but does involve some kind of disruption to the works due to COVID-19, for instance, that could entitle the contractor to an extension of time but not compensation for the delay.
And how do they measure their compensation? Where does that is that defined in terms of what can be compensated?
It will be based on the contractor's actual costs, plus an allowance for overheads potentially. I mean, it very much depends on the terms of the contract.
Right. Wow. So again, I'm assuming just like a commercial tenancy, um, I suspect people will be more interested in some of the terms of which contract gets put in front of them, whether it's the master build or the 3910 or the 3916.
Yeah, absolutely.
Cool. We've sort of come to the end of our time, and is there anything else that you wanted to add, Paul, about certainly what you're seeing and any other observations?
Yeah, I mean, I had just a further thought going back to clause 27.5 under the lease. So I guess in terms of, as I said, ideally the parties would agree on an appropriate abatement. In the absence of an agreement, the tenant is probably going to say, well, I say, this level of abatement is fair, and then they're going to pay at that level. The risk that the tenant has, if they're too aggressive in that stance, is that they could have costs awarded against them by the arbitrator. So if the landlord has said, look, let's make it 50% off, and the tenant has said, I want a 75% discount, and the tenant starts paying at 75%, and then the landlord says, and then the landlord commences arbitration, the arbitrator could rule in the landlord's favour and say actually 50% was fair, in which case the arbitrator could award costs against the tenant. Plus the arbitrator could also award the tenant default against the tenant for default interest. So on those dates when it should have been paying at 50%, but actually underpaid it because it paid at 75%, that 25% shortfall is an unpaid amount which would be subject to default interest from the date that it was due. So that would be backdated default interest.
Interesting. So then, the landlord in that circumstance, their offer of 50% would have been seen as, I suppose, what would you call that, in good faith? But what if the landlord in that circumstance, instead of saying, well, I think 50% is fair, says, no, I'm not giving you any abatement. I don't want to give you a cent. Then the tenant then starts to offer what they think is fair. Does that change how an arbitrator would possibly look at that circumstance in terms of costs or in default?
Yeah, I mean, you could have the reverse scenario. The tenant says 75% abatement is fair. The landlord says no, 0% or 25% or something. And if the arbitrator says actually, to the tenant that you were correct, what you proposed was fair, and rules in the tenant's favour, the arbitrator could award costs against the landlord in that case, because the landlord didn't need to bring the arbitration proceedings because the tenant had made a reasonable offer.
And of course, the landlord's bearing the cost of the arbitration anyway. Is that correct in terms of, like you said, the onus is on the landlord to instigate that process?
The arbitrator will make a decision as to who should pay the costs. I guess the starting point would be that the arbitrator's costs are shared between the parties. But if the arbitrator thinks that one party has acted reasonably and the other party has acted unreasonably, the arbitrator can rule that the unreasonable party pays a greater proportion of the arbitrator's costs than the other. And in the same way that court proceedings work, essentially, the victorious party is awarded costs against the other party generally.
Interesting. Well, it will be a surprise if we don't see any of this tested over the next 3 to 6 months.
Well, I suppose the difficulty that we'll have is that there could well be plenty of arbitration cases where landlords and tenants can't agree, but we're not going to see the results of those cases. They're still going to be private decisions that get issued. So it may be that we don't actually see any judicial decisions on clause 27.5. So the next time this happens, we may still be in the same position that we are now. We possibly at that point there'll be more industry norms as to what's appropriate in different circumstances, which we're lacking somewhat at the moment.
Right. Hey, Paul, again, appreciate your time. I'm just popped up on the screen If people have got any questions, they can obviously feel free to contact us at Gilligan Shepherd. And I've also included Paul's email address there at Anderson Cray Lie. Feel free to contact Paul. He's easy to deal with as far as lawyers go. And yeah, I really appreciate your insights into what will be a difficult and challenging time from now as the consequences and results of this pandemic happen.
Yeah, no, absolutely. I think we've had a good discussion.
Enjoyed it. All the best and stay safe and hope to see you soon.
Thank you. You too.
Cheers. Bye now.
Bye.